Welcome everyone. This is the Indian Express of 22nd September 2022 and I will analyze this newspaper in three steps. First is why is the news? Second is what is the news? And third is what can be the future prospects of the news. So why this news has come? Because Supreme Court has asked government about whether it has proposed something or some law to regulate the hate content in TV programs or not. So now government is standing as mute witness and treating it as a trivial matter. This was called by bench of Justices Joseph and Roy. You see, hate drives profit, so may need law, said Supreme Court, seeks government response. So this is because why hate drives profit? Because people are more interested in viewing conflicts, such hate speech, but this creates a trauma in the society. It impacts society in such a way that it cannot be reversed. So we will see what Supreme Court has really flagged. Expressing its anguish and displeasure over hate speeches via debates on TV channel. The Supreme Court Wednesday called the visual media, that is TV channels, the chief medium of hate speech, and it questioned the government why it is standing by as a mute witness when all this is happening and why government is treating this issue as a trivial matter, pointing out that hate speech can be in different forms, sort of ridicule a community. We have seen these things in the past, and even the world has seen this incidents in India. For example, Nupu Sharma hate speech towards Prophet Muhammad. It gained worldwide attention, and a lot of people in the world condemned it, and its spread through the visual media can have devastating effect. This was by the bench of Justices K.M. Joseph and Hirkesh Roy, inclined to regulate such debates. They asked the center to state whether it proposed to come up with any law on the subject. The bench underlined that hate drives TRPs. This is 100% true. Whichever channels are showing hate speech and violent things are driving TRPs. And this TRP, because of more viewers, are coming towards that channel, and this drives profit. And said it will consider laying down some guidelines which will hold the field until the legislature comes up with a law on that matter. So until any law comes on hate speech, Supreme Court will lay down some guidelines that will hold the field, that will make that hate speech in a regulation. What we have in mind, for example, when you conduct an interview, what is important is laying down the methodology. Now they are recommending a methodology, that they are saying that now the methodology would be what is the role of the anchor. If the anchor is going to take lion's share of time of the debate, if the question of the anchor is so long, finally the time which is given to person who is giving the answer is so short. So he is asking that what is the time period that anchors take in that show. If it is the most, which is the lion's share, if it is the largest, then the time given for the person who are answering is obviously it will be short. And even in that short period, he is actually run down. He is made into some kind of rogue. So he is asking that such types of questions are asked so that some kind of violence, hate comes out of that person. You have to be fair to everyone. So that is what we are interested in saying, apart from contours of hate speech, till it is defined appropriately by the competent legislature. So they are asking that Just do not be biased. Be fair with every party that comes. The bench was hearing a clutch of petitions on alleged hate speech via some TV shows. Petitioners have sought directions from the court to the center to take steps to curb incidents of such speech. So bench was hearing petitions that were about hate speech, and petitioners have asked the court to take steps to stop these incidents of hate speech. Justice Joseph said that the problem will go on unless there is an institutional mechanism to deal with it. And what can be done till the government acts is to possibly consider acting on the lines of Vishakha case, where the top court laid down guidelines to tackle sexual harassment at workplace. So this is about Supreme Court's regulation that until the government is coming up with a legislative law, the Supreme Court will make guidelines based on this Vishakha case. So what can be done till the government acts is possibly consider. So it can consider working on the lines of this case. So in the same method as it is used to deal with sexual harassment at workplace, same method will be used to deal with the hate speech. So now they are saying that let us try and do what we can. We can't be taking over the powers of legislature. So they think that Vishakha is the best model because lawmaking is the work of legislature. It's not the work of judiciary. So they are not taking the powers of the legislature, but they are trying to at least lay some guidelines for people to follow so that they can to some degree curb this hate speech. The Council for Broadcast Regulator apprised the bench how it has been acting with regard to the channels, including by levying penalties. Also, they are thinking about some penalties to those channels who are spreading hate speech or they are inciting some hate speech. But Justice Roy said that unless the consequences of infringement come hard on the person who is violating, how will the message go? So this is about until and unless the consequences of the same hate speech come hard on the person. So the person who is actually speaking hate about other communities or other person or anything, until he faces the consequences, the message will not go. You have passed 4,000 orders. Has there been any effect of the 4,000 orders that have been passed? Hate drives TRPs. It drives profit. So the chicken feed kind of penalty is flimsy. Their pockets will not even get a little tear there. So that means if you just impose a penalty, they will give it to them and they will not feel any kind of loss because their pockets are so heavy that penalty will be just a little amount of sum. So penalty is just a flimsy. They will not get even a little tear there. That means they will not even feel even little loss. So Justice Chaucer said the most important point is where is our nation headed? If it is hate speech that we are actually feeding on, where is our nation headed? So if we are making hate in our society, in our nation, where do you think the nation will head? If you spread violence, violence will get into the head of every citizen. And that is why various incidents of such violence are seen in the streets. Turning to the Centre's counsel, he asked, what is your stand? Have you filed a counter affidavit? What is the stand taken by the Government of India? Why is the Government of India standing by as a mute witness when all this is happening? Political parties will come and go, but the nation will endure. You see, press is a very important institution. Democracy works on four institutions: legislative, executive, judiciary, and media. So you see, it's a fourth pillar. Without an independent and totally free press, no nation can go forward. It's absolutely important that we have true freedom. One should actually come forward not to take an adversarial stand, but to assist, to say that you have put in place an institution which will be abided by all. Then what is the problem? Why should the government of India have a problem with that? And asked, why do you take it such a trivial matter? So this was asked by Supreme Court. The council said government had not treated it as a trivial matter. He pointed out that on the previous occasion the Supreme Court has asked the government to collate information from the states on compilation of some of the court's earlier direction, and added that only 14 states have responded so far. So something was asked by Supreme Court to the government, and government, only 14 states responded to these court's earlier directions. Now court asked government to submit a response within 2 weeks with whatever information it had collected. So now after 2 weeks government will submit a response about what information it has get and clearly indicate its stand. So till now it has been mute, but now it has to speak about what is the stand with regard to recommendations made by law commissions of India in this regard, and whether it is contemplating any legislation in terms of the recommendations. So now Supreme Court is asking that after 2 weeks you have to tell, government have to tell that what is your take on such issue, such hate speech issue, and whether you are going to make any law in terms of recommendations or not. So Advocate Ashwini Upadhyay, who is one of the petitioners, urged the court to issue notice to Press Council 2 in case it wanted to examine hate speech in the media. So he asked to issue notice to the Press Council if Supreme Court want to see what is the position of hate speech in the media. So Justice Joseph said that we made a reference to this visual media because chief medium of hate speech is apparently through the visual media. You see, internet and channels, TV channels, all of these visual media are the main sources, or you can call medium, of hate speech. In paper somebody writes something, nobody reads, nobody has the time, but visual media has got a power which has been recognized by this court right from the case relating to censorship. You see, nowadays visual media are very clear. In fact, people read papers because of getting a legitimate news and also some kind of reading habit, but visual media comes very forward when it comes to print media because it has an effect. You see face to face and everything, so it storms your brain more. So if there is a violence in the visual media, it will certainly affect the brain more. Then if you read something written, so it will be forgotten, but visual things does not get clears from head very soon. So the difference between visual media and print media is so clear that it has got a devastating effect. So this is again emphasized by Supreme Court that visual media, if visual media is good, then it can have a good effect, but if bad, then not a bad effect, in fact a devastating effect. Asking the parties not to take it as an adversarial litigation, Justice Joseph said that because all of us are interested in only one thing, that it functions as a real fourth estate, which is press. So you see, press is a fourth pillar of this. Whoever says whatever it is will be accountable. it is responsible democracy. Not anyone can say anything and get away with it. So you cannot speak anything, you cannot disrespect any kind of community, religion, person and get away with it and sneak out with it. It means you cannot be left. If you say anything hate about other person, the point is, when you run a program, can you run down anybody, any community, any individual? So you run a program, you cannot shame, you cannot disgrace, disrespect anybody, any community, any individual. Just look at what he feels. So if you do something to someone, that means if you do some hate related thing to someone, look at what he feels. Everybody belongs to this republic. We should foster those constitutional values. Actually, when they do anything, their acts, their expression, every word they use and every word they don't use, their omissions, all of this is transmitted. You see, anyone can see the expression of hate in the face, and words express that a person is saying good thing or bad thing. In fact, the hidden words, the hidden meanings also express that you are saying hate things about anyone. Now everybody is watching you. When you see it, what is it that you are conveying? Everybody belongs to this nation, he said. So this will be discussed after 2 weeks. What is the future prospect? 2 weeks are left for government to check out what it found, and then after it have to speak about this hate speech incident, and it cannot take this matter as a trivial matter after 2 weeks. So this was about the hate speech. Now this news is important. Draft bill moves to regulate internet-based OTT telecom services. So there is a rule that is coming on, which is Indian Telecommunications Bill 2020-22. Department of Telecommunications Wednesday proposed regulating communications services including voice, video and data offered by over-the-top platforms such as WhatsApp as telecom services, requiring them to obtain a license from the government just like other telecom operators. So this is a form of communication such as sending voice, sending video. Also there is a calling system in WhatsApp. So now WhatsApp and other such platforms that use communication will have to take license from the government, just like other telecom operators such as BSNL, Jio, Vodafone, Airtel. All of those have taken license in the same way WhatsApp and other such platforms have to take license from the government too. In a draft Indian Telecommunication Bill, so this is a bill which is released in public domain late Wednesday, Department of Telecommunication has also proposed to dilute some crucial powers and responsibilities of the TRAI, Telecom Regulatory Authority of India, on issuing new licenses to service providers. So it is saying that it can somewhat dilute crucial powers and responsibilities, and if these companies come forward to take the license, they can get the license. The draft bill consolidates 3 separate acts which currently governs the telecommunication sector. First is the Indian Telegraph Act 1885, then second is Indian Wireless Telegraphy Act 1933, third is Telegraph Wires Unlawful Protection Act 1950. So what is there in the draft bill? You see, government has included internet based OTT communications such as WhatsApp call, FaceTime, Google Meet. These are based on internet. They are not based on such things that telecom operators are based on. They're not based on radio frequency, they are internet based communication system. Under telecom sector, addressing a long standing demand by telecom operator which have on several occasions called for a level playing field. So this was a demand from telecom operators that if we have the license and we work on the license basis, then these services that provide internet based communication must also have a license. At present, while telecom companies need a license to offer services, OTT platforms do not. So bringing OTTs under the ambit of telecom services means that OTT and internet based communication would require a license to offer services. So it is clear that they will also require license. In the draft, the Department of Telecommunications has also said that it could exempt entities from the requirement of obtaining a license if it is in public interest. So there can be an exception of obtaining a license if that entity, if that operator is working in a public interest. The draft bill also states that the information transmitted and received over telecommunication services could be intercepted by an authorized official of the government in the interest of sovereignty, integrity or security of India. Also friendly relations with foreign states plus public order or preventing incitement to an offence. So this is very clear that the telecommunications which are through SIMs, which is Jio, Vodafone, all of that. So callings are recorded and they can be shared by the authorized official if the government needs that in terms of sovereignty, integrity, security or to maintain public order. The same way these internet based communications, these calling will be transferred to government if government needs that. So this can be a major conflict about privacy and helping government in terms of its security. So now it is unclear how this particular provision could potentially impact calls over WhatsApp, which are typically end-to-end encrypted, meaning that company itself does not have the access to information being transmitted over such calls. You see, the WhatsApp do not have such access to the information. It is an end-to-end encrypted. Then how come this WhatsApp can give such information to government? So it has to change its rules, whether work with the government rules or leave the platform. The draft bill proposes amendments to the Telecom Regulatory Authority of India Act 1997. At present, this TRAI Act requires the government to seek the regulators' recommendations before issuing licenses to service providers. So this is the method by which it is done. It also allows the TRAI to request the government to furnish information or documents that are necessary to make recommendations. So these powers have been proposed to be removed in the new draft bill. So this is clear. Now what will we expect in future? How come these internet based calling communication will share the information with government, and will they agree? Because most of these companies are from US. WhatsApp, Facebook, Google, Twitter, all of these are based on US, and previously a lot of clash was on the users' privacy relating to WhatsApp. All this clash occurred in 2021. So now come this new bill, and how exactly these operators that are based on internet will respond to this bill. This will be clear to see. So now we will move to next page, which is city page. Again more of city page. Then there is international and India based news, which is India was suspicious of US for nearly 5 decades. Jaishankar, S. Jaishankar, this was called by Minister of External Affairs. So why is this news? Because Jaishankar in is in US, currently in New York, and he was discussing this matter with Professor Anvint Panagria at an interactive discussion at the School of International and Public Affairs. You see the picture, now we will see what is exactly the statement that he called for. So he said that for nearly 5 decades, India looked upon US with suspicions, and its overall foreign policy assessment of the US was of deep caution. But the country has now overcome the assumption to forge a different relationship with America. So you see, first India was a little bit tilted toward USSR and saw America as somewhat with caution, with vigilancy, but now relationships are very much different what it were decades ago. Jaishankar also said he wanted to give out the message that it was in the mutual interest of India and China to find a way to accommodate each other. We have seen such accommodation between India and China, because China have pulled out its soldiers from the last clash point, which was Kogra post in the eastern Ladakh. So this was a good move from China, and we hope that also such a friendship will occur, although this is very critical of that. We have also seen no bilateral talks between India and China in the SCO, which everyone was expecting after such a move from China. Now next is Jaishankar was speaking at the Columbia's University School of International and Public Affairs in New York with former Niti Aayog chairman and Columbia University professor Arvind Panagria on India in the emerging global order. Take a attitude towards the United States between the late 40s and I would say 2000, the year Clinton claimed to India. For almost 50 years, for various reasons. I'm not saying we were at fault or the US was at fault, but the fact was we regarded the US with suspicion, with a lot of wariness. It was a very substantive relationship, but the overall foreign policy assessment of the US was of deep caution, if not of deep suspicion. So he's talking that we looked at US with slight caution. We were not in trust with US, if not of deep suspicion. Now the fact is, when the world began to change, the tenability of that view came into question. So something changed in the world. There was a tilt. Soviet Union got dissolved. US became a hegemony in this global world. So all of these changed. We struggle. Even the nuclear deal in 2005-8 was a struggle, because on the one hand, the US was offering some very clear advantages. What held us back was the innate, historical, deeply rooted, possibly validated suspicion of United States. We kind of said this is a gift horse. Might we really need to look at it in the mouth? This means that there was a nuclear deal, and there was a nuclear deal in 2005-8, and US was offering some very clear advantages. US was giving clear advantages, but it was held back because of suspicion on United States. Jaishankar credited Prime Minister Narendra Modi in reshaping India's relation with the US. It has taken us a lot of to overcome the earlier assumptions in order to forge a different relationship with the US, and one of the big differences which PM Modi has made he has not carried ideological baggage. He is not a person who is rooted in a certain worldview, which makes you fundamentally distant from the US, he said. So then comes the government and politics page, which has no such news. It is mostly based on political news. Again comes Express Network page. Right to wear a hijab in school not a fundamental right. This has been called by state government, which is Karnataka state government, to Supreme Court. So this is regarding Karnataka hijab ban. Why is this news? You know this news is coming since a year. In fact more since 1 week. So what is the matter? Women who do not wear the hijab as a matter of choice, or women in countries such as Turkey and France which prohibited wearing the hijab, do not become any less Islamic just because they don't wear it. The Karnataka government told the Supreme Court on Wednesday while explaining why the practice will not qualify as an essential religious practice. Today we have a large number of sisters and mothers that belonging to Islamic faith who as a matter of choice do not wear hijab. We have countries like France and Turkey which have prohibited wearing of hijab. But in both these situations, when a woman does not wear a hijab, she does not become less Islamic. So this is very clear language, and it is written that some countries are there which have prohibited wearing of hijab, but not wearing a hijab does not make you less Islamic. This was Advocate General of Karnataka Prabhuling Nawadgi told a bench of Justices Hemant Gupta, Sudhanshu Dhulia. Now the bench is hearing appeals against Karnataka's High Court order dismissing petitions by some Muslim girls, students of pre-university colleges in Udupi, seeking right to wear hijab in classroom. So this is about the petitions. So High Court have already passed its order, but the appellants were not satisfied, so now they have submitted their petitions and appeals to regarding Karnataka's High Court order. Nawadgi said that these could be some of the tests to understand if wearing hijab is so compulsory, if it's something so fundamental without which you are going to be a non-Muslim. When we enter an educational institution, both students and administrators are governed by the Education Act. It is a complete act in itself, and the question of violation of fundamental rights does not arise. So you see, they are asking the validity of this educational act. He said that this act is complete in itself. It is itself a complete act. So how can it violate the fundamental right? This question does not arise. Also, he contended that right to wear a dress in an educational institution in defiance of a school regulation is not a fundamental right as such. So you cannot wear any dress in the college. In the same way, right to wear a hijab in a school is also not a fundamental right. What he called on ban, he said that we do not place restrictions on wearing a hijab outside classrooms. We do not prohibit them from coming to school without hijab even in school or college transportation. There is no restriction even on a school campus. The restriction is only inside the classroom. So this is clear, referring to Shaira Bano case in which Supreme Court held the practice of triple talaq unconstitutional. He submitted that mention in Quran may make something religious, but whether that makes it essential has to be tested using the test already laid down by the court. So he said that this hijab wearing or Quran, this hijab wearing or triple talaq may be mentioned in the Quran, but whether it is an essential practice has to be tested. Now Nawadgi said one of the arguments of Muslim appellants was that those who do not follow the commands of Quran will be answerable in afterlife. So this was the question, that if you do not follow the commands of Quran, you have to answer in the afterlife. It is too general to say so. The obligation must be provided in the text itself. So it is called in every religion. You see that Paap, Punya and all that is in every religion. If you do not follow the commands of God, Quran, you are not a good person, you will be unstable in afterlife. So there must be a legitimate text that is written So he is asking that obligation must be provided in the text itself. Now asked by the bench why the state did not urge the High Court to venture into deciding whether it was essential religious practices, why it did not decided that whether wearing hijab was an essential religious practice or not. Nawatgi said that at one point of time the state council were reluctant to interpret the Quran, but when the petitioner asserted that it was an essential religious practice, we relied on Supreme Court judgment to say that these tests are not satisfactory. So at first time they were reluctant on interpreting the Quran. They were busy doing that. But when the petitioner asserted that wearing hijab is an essential religious practice, then they relied on Supreme Court judgment. Countering arguments that wearing hijab is a fundamental right of expression, he said that appellants had not placed any material on record to establish the claim. So there is a claim also that it is a matter of self-expression. Wearing hijab is a fundamental right of expression, wearing a clothing. But Nawatgi said that they had not placed any material on record to establish the claim. They have not put any kind of evidence to prove that this claim is true. The court pointed out that argument is if a girl wear a hijab in a mall, how does she lose the right when she steps into the school compound? So this was also argument, if you can wear a hijab in any other place other than school, then how can you lose that right when you go into the classroom? So on this argument, Nawatgi responded that there is nothing like absolute freedom and that every freedom can be restricted and controlled in the manner known under the Constitution. So freedom is not absolute, we know that. There can be certain situations in which these fundamental rights, in fact some of them, can be dissolved, for example in emergency. So every freedom can be restricted and controlled in a manner known under the Constitution. So now explaining the predicament of school management, he said, what do I do as a school principal? My primary concern is to run the school, to ensure that there is no animosity, not to decide whether it is an essential religious practice. So he said that school principal's work is to ensure that there is no indiscipline, no animosity, not to decide whether a religion has some essential religious practices or not. So this was decided. Now there will be more of these news coming in. We will see this in the future. So next come the explained page. You see a big headline, live streaming of Supreme Court proceedings, rationale and concerns. So what can be the benefits of it and what are the real concerns over live streaming? So you see, Supreme Court in a full court held on Tuesday decided to live stream its proceeding in crucial constitutional bench cases that will be heard from September 27. This decision comes nearly 4 years after a plea was made in the interest of transparency. So there was a plea made so that there can be transparency in Supreme Court judgments. So that is why now there will be a live streaming. What is the history of this case? August 26, on the day of former Justice of India CJI N.V. Raman's retirement, the Supreme Court streamed its proceeding live. But the first step toward the decision were taken in 2018, when a 3-judge bench comprising then CJI Deepak Mishra, Justice A.M. Khanvikar and Justice T.Y. agreed to hear a public interest litigation seeking live streaming of judicial proceedings on matter of constitution and national importance. So this was the first time. Now there are petitioners who cited the principle of open access to justice, including senior advocate Indira Jaisingh. These were the people who are petitioning that there must be an open ruling, open judgment. March 2018, Supreme Court issues notice to Attorney General of India K.K. Venugopal seeking his views on the issue. So they issued this notice to know what is the view of K.K. Venugopal, who is Attorney General of India, on this live streaming issue. This was recommended by AG. In his response to the court, Venugopal recommended introducing live stream as a pilot project in court number 1, which is the Chief Justice of India's court, and only in constitution bench cases, so not in some private matters. Only those cases that are related to constitution or something like that, or national importance. The success of this project will determine whether or not live streaming should be introduced in all courts in Supreme Court and in courts pan-India. So pan-India means presence across nation. So whether it means all of the India. So whether it should be introduced in all courts of Supreme Court and in the all presence over across India, he said. So the Attorney General cited decongestion of courts and also want to improve the physical access to court for litigation who have otherwise traveled long distances to come to Supreme Court in support of his recommendation. So he told about the access to courts. So if this is virtual, then anybody can have access to court. Otherwise, they have to travel long distance. Supreme Court approved a set of guidelines that were suggested by Attorney General, and that included allowing transcripts and archiving the proceedings. That means there will be live transcript and archiving the proceedings. So which means that proceedings will not be deleted but instead be made hidden. However, the AG suggested that court must retain the power to withhold broadcasting and to also not permit it in cases involving. So these cases which are of private matters and some other things, like first is matrimonial matters, they will not be published, they will not be broadcasted. Second is matter involving interest of juveniles or the protection and safety of private life of the young offenders. Third is a matter of national security. Fourth is to ensure that victims, witnesses or defendants can deposit truthfully and without fear. So special protections must be given to vulnerable or intimidated witnesses. It may provide for face distortion of the witness if he contends, so some kind of blurring system in the video, if he or she consents to the broadcast anonymously. Also to protect confidential or sensitive information, for example, all matters relating to sexual assault and rape, the matters where publicity would be antithetical to the administration of justice, and also cases which may provoke sentiments and also arouse passion and provoke enmity among communities. So all these cases will not be broadcasted. Live streaming in High Court. Following the Supreme Court decision, Gujarat High Court also began live streaming its proceedings in July 2021. Currently, Jharkhand, Karnataka, Madhya Pradesh, Orissa, Patna High Court live stream their proceedings. So all these states do live streaming. Allahabad High Court is learned to be considering doing the same. So what are the concerns over live streaming? So broadcasting court proceeding is a step in the direction of transparency and greater access to justice system. So it is seriously made for transparency and also for access to the most vulnerable people who do not get it. But there are also concerns around the impact of live streaming, both on judges and also the people watching the proceedings. Video clips of proceedings from Indian courts are already on High Court, already on YouTube and other social media platforms with sensational titles and little context, such as High Court super angry on army officer. So these are some sensational titles that are used in YouTube by other YouTubers. So there are fears that irresponsible or motivated use of content could spread disinformation among the public. So there is a concern of disinformation and over hypersensitized news. In 2018, paper by Felipe Lopez titled Television and Judicial Behavior: Lessons from the Brazilian Supreme Court This paper studied the Brazilian Supreme Court and concluded that the justices behave like politicians when given free television time. They act to maximize their individual exposure. So this is something critical of it, that judges behave like politicians when they are on TV, and also they want more exposure of themselves. They want to just be there on the show and exposed. There are also studies that investigated the effects on the behavior of politicians on the introduction of C-SPAN in the US House of Representatives and US Senate, which concluded that broadcast of proceeding corresponded with growth in the frequency of filibustering. So this is another study, however something positive. So this is all negative, we are moving to a more positive. What is the positive effect? However, some positive systematic corrections have been made possible due to the broadcast of court proceeding. 2017 study by researchers at Northwestern University of Archives of the audio proceeding of US Supreme Court showed that judicial interactions at oral argument are highly gendered, with women being interrupted at disproportionate rates by their male colleagues as well as by male advocates. Last year, SCOTUS Justice Sonia Sotomayor said that the gender disruption identified by the study have been addressed, and now justices ask questions according to seniority instead of interrupting in a random way. So this was reading. Now I will explain what was there. So if these representatives of the US House are broadcasted, then there is a growth in the frequency of filibustering. So this filibustering means intentionally delaying the debate. So this is done by representatives. So in order to make that debate more delayed, they do that intentionally. However, some positive systematic corrections have been made possible due to the broadcast of court proceeding. Now 2017 study searched that females are interrupted at disproportionate rate by their male colleagues, also by male advocates. So now what is the action that has been done is that the justices now ask question according to seniority instead of interrupting in a random way. So they ask whoever is senior, female or male. Such interruptions by the male colleagues and male advocates now have become less. So what can be the future prospects? You see, Indian YouTube is full of such sensational titles. So court have to think very cautiously whether they will prevent this thing or not. And in order to take all these steps, they also have to maintain security and prevent these YouTube sensational videos coming up in the platform. So next come the world news, which has Russia-Ukraine war over that, and what Biden, who is a US president, has called that Russia shamelessly violated UN Charter in Ukraine. And he said that Russia is keeping its brutal, needless war, and US will stand towards Ukraine effort to defend itself. So this is clear. We are looking more for the India and international such news. So there is no such news given. Now moving to economy page. Semiconductor PLI support for 50% of project cost cleared. So this is something which is important. Union Cabinet approved on Wednesday changes to Centre's 76,000 rupees 76 crore semiconductor production in incentive scheme, allowing for uniform fiscal support of 50% of project cost for semiconductor fabs across technology nodes and display manufacturing. This means that if you open up some semiconductor based technology industry, then this PLI scheme will support you with 50% of project cost. So this is only important. This is of great help because India wants to become up and reduce its dependence on China. So this was it. There is not much news about India. This comes an end to the newspaper. Now you can read this newspaper by yourself as well.